Welcome back to the channel. In today's AS and A-level law revision session, we'll be focusing on exclusion clauses in the law of contracts. We'll examine what exclusion clauses are, why businesses use them, and the different types you need to know for your exams. We'll also look at how exclusion clauses become part of a contract, how courts interpret their wording, and the legal controls placed on them through common law and legislation, including the Unfair Contract Terms Act. Throughout this lesson, we'll break down the key principles and important cases you need for effective revision and stronger exam answers. By the end of the video, you should have a clear understanding of how exclusion clauses work and how to explain their legal effect with confidence in your AS and A-level exams. As we begin, it's important to understand the role contracts play in everyday commercial relationships. Contracts create legally binding agreements that define the rights, duties, and obligations of the parties involved. However, not every contract goes smoothly. Businesses and organizations often face risks such as financial loss, damage, delays, or legal claims. To reduce these risks, many contracts include exemption clauses, also known as exclusion or limitation clauses. These clauses are designed to restrict or exclude liability in certain situations, particularly when there has been a breach of contract or negligence. For example, a business may attempt to limit the amount of compensation it has to pay if something goes wrong. Exclusion clauses are also an important form of risk management. They help businesses control potential losses and provide greater certainty when entering agreements. But because these clauses can sometimes operate unfairly against one party, the courts carefully examine them. The law requires that exclusion clauses are properly incorporated into the contract, clearly worded, and fair under both common law principles and statutory controls. Understanding these principles is essential for AS and A-level contract law, as they form the foundation for many exam topics linked to contractual liability and fairness. To understand exclusion clauses properly, it helps to look at how they developed over time. Their origins can be traced back to the 19th century, during a period when the principle of freedom of contract dominated contract law. Courts believed that parties entering contracts were equal and free to negotiate whatever terms they wished, regardless of differences in bargaining power. Because of this approach, the early judicial attitude strongly favored enforcing contracts exactly as they were written. Influenced by the principle of caveat emptor, meaning buyer beware, courts were generally unwilling to help parties who had agreed to unfair or disadvantageous terms. However, by the mid-20th century, judges became increasingly concerned about unfairness, especially in standard form contracts where consumers had little real opportunity to negotiate terms. As a result, courts began developing stricter legal rules to control exclusion clauses. Two important concepts emerged during this period: incorporation and construction. Incorporation focuses on whether the clause actually became part of the contract, while construction examines how the wording of the clause should be interpreted. One of the most significant legal principles is the signature rule, established in the case of Lestrange v. Graukob in 1934. The court held that when a person signs a contractual document, they are generally bound by its terms, even if they did not read them. Today, however, this rule is not absolute. Modern contract law recognizes that some clauses may be unfair or hidden within agreements. Courts now apply statutory controls and common law principles to ensure exclusion clauses operate fairly and transparently. This evolution reflects the balance contract law tries to achieve between freedom of contract and protecting parties from unfair terms. Now, let's examine the main types of exemption clauses that appear in contract law. The first type is the exclusion clause. An exclusion clause attempts to completely remove legal responsibility for certain losses or breaches. In other words, one party seeks to avoid liability altogether. For example, a contract may state that a business will not be responsible for losses caused by delayed delivery or service interruptions. The second type is the limitation clause. Unlike an exclusion clause, this does not remove liability completely. Instead, it places a limit or financial cap on the amount that can be claimed. For instance, a seller of goods may limit compensation for defective products to the value of the original purchase price. The third type is the indemnity clause. This clause requires one party to compensate another for losses or legal claims brought by third parties. Essentially, One party agrees to cover certain risks or expenses on behalf of the other. Indemnity clauses are commonly used in commercial agreements, where businesses want protection against potential claims arising from contractual performance. Although these clauses differ in their effect, they all share the same general purpose: managing and allocating risk between the parties to a contract. For AS and A-level law, it is important to clearly distinguish between exclusion clauses, limitation clauses, and indemnity clauses, as exam questions often test your ability to identify and explain these differences accurately. Let's now look at the main purpose of exemption clauses within commercial contracts. One major reason businesses use these clauses is risk regulation. In high-value commercial agreements, the financial risks can be extremely large. Exemption clauses help businesses manage that exposure by controlling the extent of liability if something goes wrong during the performance of the contract. These clauses are also used to provide protection against product misuse. In many consumer transactions, sellers cannot fully control how buyers use a product after purchase. If a customer ignores instructions or uses a product improperly, a business may attempt to limit its liability for any resulting loss or damage. Another important purpose is the management of uncontrollable events. Some losses occur because of circumstances outside a party's control, such as network failures, transportation delays, natural disasters, or other force majeure events. Exemption clauses can help allocate responsibility for these unexpected situations. Exemption clauses also help prevent disproportionate burdens. Without limitations on liability, businesses could face extremely large claims that are far beyond the value of the contract itself. These clauses aim to create a more balanced distribution of risk between the parties. Finally, they help businesses deal with uncertainty. Commercial transactions often involve unpredictable problems such as system failures, shipping issues, or delays in performance. By defining liability in advance, exemption clauses provide greater certainty and reduce the likelihood of costly disputes. However, while these clauses serve important commercial purposes, the law still places controls on them to ensure they are fair, reasonable, and properly incorporated into the contract. Although exemption clauses play an important role in managing commercial risk, businesses cannot use them without legal limits. To prevent unfairness and abuse, the law has developed a framework to regulate how these clauses operate and when they can be enforced. In the United Kingdom, the regulation of exemption clauses follows a dual approach. The first part of this framework comes from common law principles. Over time, judges developed legal rules through case law to determine whether an exemption clause should be recognized by the courts. These principles focus on issues such as incorporation, interpretation, and fairness. In other words, the courts examine whether the clause properly became part of the contract and whether its wording clearly covers the loss in question. The second part of the framework comes from statutory controls. Parliament introduced legislation to provide stronger protection against unfair contractual terms, especially in situations where one party has significantly greater bargaining power than the other. These statutory rules place limits on the use of exemption clauses, and in some cases, make certain exclusions completely unenforceable. They also allow courts to assess whether a clause is reasonable and fair in the circumstances. Together, common law principles and statutory controls form the foundation of modern regulation for exemption clauses. As we continue, we'll examine each of these areas in more detail, beginning with the common law rules developed by the courts. Now that we've introduced the legal framework governing exemption clauses, we can focus more closely on the role of common law. At the heart of common law regulation is a balance between two important ideas: freedom of contract and judicial fairness. On one hand, the law respects the right of parties to decide the terms of their agreements freely. On the other hand, the courts also recognize that exclusion clauses can sometimes operate unfairly, especially where one party has greater bargaining power. An exclusion clause, as we know, is a contractual term designed to limit or completely exclude liability for breach of contract or negligence. To prevent abuse, the common law acts as a kind of gatekeeper. Before an exclusion clause can successfully protect a party from liability, it must overcome three important legal hurdles. The first question is incorporation. Was the clause properly included in the contract? The court will examine whether sufficient notice was given, or whether the clause was included through signature or previous dealings between the parties. The second question is construction. sometimes called interpretation. Does the wording of the clause actually cover the loss or damage that occurred? Courts interpret exclusion clauses very carefully, especially where negligence or serious breaches are involved. The third question is whether another rule of law invalidates the clause. Even if a clause has been incorporated and clearly drafted, it may still fail if legislation or legal principles declare it unfair or unenforceable. These three hurdles form the foundation of common law control over exclusion clauses, and each one plays a crucial role in determining whether a clause will ultimately be effective in law. Let's now move to the first major hurdle in common law control: incorporation. Before an exclusion clause can be enforced, the party relying on it must prove that the clause actually became part of the contract. Under common law, incorporation can happen in three main ways: by signature, by notice, or through a previous course of dealing. We'll begin with incorporation by signature. The general rule is very strict. When a person signs a contractual document, they are bound by its terms, even if they did not read or fully understand them before signing. This principle was clearly established in the important case of Lestrange v. Graucob. The court held that a signature acts as objective evidence of agreement. Once a contractual document is signed, the signer is normally legally bound by all of its terms, including any exclusion clauses contained within it. This rule reflects the importance contract law places on certainty and reliability in commercial transactions. If signatures could easily be ignored, contracts would become far less dependable. However, there are important exceptions to this principle. One key exception can be seen in the case of Curtis v. Chemical Cleaning Company. In this case, the claimant signed a document after being given a misleading explanation about the clause it contained. Because the explanation misrepresented the true effect of the term, the exclusion clause could not be fully enforced. This shows that while the courts generally uphold signed agreements, they will not allow one party to rely on a signature obtained through misrepresentation or misleading conduct. So, incorporation by signature demonstrates the balance courts attempt to maintain between enforcing contractual certainty and preventing unfairness. In many everyday transactions, people do not sign a formal agreement. Instead, terms may appear on tickets, receipts, notices, or booking confirmations. In these situations, the courts apply a series of tests to decide whether an exclusion clause has been properly incorporated into the contract. The first test focuses on the nature of the document. The court asks whether the document is one that a reasonable person would expect to contain contractual terms. For example, in Parker v. Southeastern Railway, a ticket was considered capable of containing contractual conditions because people generally expect tickets to include terms. However, if the document appears to be nothing more than a receipt or voucher, the clause may not be incorporated. This was demonstrated in Chapelton v. Barry Urban District Council, where the court held that a deck chair ticket looked like a mere receipt rather than a contractual document. The second test concerns timing. Notice of the exclusion clause must be given before or at the time the contract is formed. If the clause is only brought to a person's attention after the agreement has already been made, it will usually be ineffective. A well-known example is Ollie v. Marlborough Court Hotel, where a notice displayed inside a hotel room could not be enforced because the contract had already been formed at reception before the guest saw the notice. The third test is sufficiency of notice. The party relying on the clause must take reasonable steps to bring it to the other party's attention. Importantly, they do not need to prove that the clause was actually read, only that reasonable notice was given. This principle can be seen in Thompson v. LMS Railway. However, where a clause is particularly harsh or unusual, the courts demand a much higher standard of notice. This is known as the red hand rule, developed in Thornton v. Shoe Lane Parking. Lord Denning explained that especially burdensome clauses must be displayed very prominently, almost as though a red hand were pointing directly to them. Together, these rules show how the courts attempt to ensure that exclusion clauses are not hidden unfairly within unsigned documents. Another important method of incorporation is incorporation through a previous course of dealings. In some situations, an exclusion clause may become part of a contract, even when it is not specifically mentioned or signed during the current transaction. This can happen where the parties have regularly conducted business with each other, under the same terms, over a period of time. The courts focus on two main factors: regularity and consistency. The previous dealings must occur frequently, and the contractual procedure must remain largely identical each time. This principle was examined in McCutcheon v. McBrain. The court held that occasional use of contractual terms was not enough to establish a consistent course of dealing. Since the claimant had only signed the terms during some previous transactions, the exclusion clause was not automatically incorporated into the contract. The courts are also more protective when consumers or private individuals are involved. In Hollier v. Rambler Motors, only a few transactions over several years were considered insufficient to create a recognized course of dealing. This reflects the court's reluctance to bind consumers to unexpected exclusion clauses. However, the position may differ between experienced commercial parties operating within the same industry. In British Crane Hire, the court accepted that standard industry terms could apply because both parties were businesses familiar with the usual practices of the trade. Overall, the courts require evidence that the parties' behavior was so regular and well established that both sides reasonably understood the exclusion terms would continue to apply. This method of incorporation highlights how previous commercial relationships can influence contractual obligations, particularly in business transactions where standard terms are repeatedly used. Having explored incorporation through previous dealings, we now move to another important issue connected to exclusion clauses: privity of contract. The doctrine of privity means that a contract generally only affects the parties who entered into it. In simple terms, a contract operates like a private agreement. Only those who are part of the contract can enforce its terms or rely on its protections. This created a major problem in relation to exclusion clauses. Traditionally, third parties such as employees, agents, or subcontractors could not rely on an exclusion clause contained in a contract because they were not actual parties to that agreement. This issue was highlighted in the case of Scrutins v. Midland Silicones. The court held that even though the contract attempted to limit liability, an employee or third party could still be sued personally because they were outside the contractual relationship. As commercial relationships became more complex, this strict rule created practical difficulties, especially where businesses relied heavily on employees and subcontractors to perform contractual duties. To address this problem, Parliament introduced the Contracts Rights of Third Parties Act, 1999. This legislation allows certain third parties to rely on contractual terms, including exclusion clauses, in specific circumstances. For example, a third party may enforce or rely on a clause if the contract expressly states that they can, or if the term clearly intends to confer a benefit upon them. The Act therefore modernized the traditional doctrine of privity and made it easier for businesses to extend contractual protections to people involved in carrying out the contract, even when they are not original parties to the agreement. Having examined privity of contract, we can now look at two additional concepts connected to incorporation and exclusion clauses: collateral contracts and the battle of the forms. First, let's consider collateral contracts, sometimes described as the side door approach. A collateral contract is a separate agreement that exists alongside the main contract. Its importance lies in the fact that an exclusion clause in the main agreement may not protect a party who breaches a separate collateral promise. The key idea is that the collateral promise creates its own independent contractual obligation. This principle can be seen in Andrews v. Hopkinson from 1957. In that case, a car dealer gave a specific assurance about the quality of a vehicle, describing it as a good little bus. The court treated this statement as a collateral contract. As a result, the buyer was able to sue based on that separate promise, even though the main finance agreement attempted to exclude liability. Collateral contracts therefore show that courts may sometimes bypass exclusion clauses where a clear and separate promise has been made. The second concept is the battle of the forms. This commonly arises in commercial transactions where two businesses exchange their own standard terms and conditions during negotiations. Each side attempts to ensure that its own terms govern the contract. Under contract law, each new set of terms is usually treated as a counteroffer, effectively replacing the previous offer. This leads to what is known as the last shot rule. Generally, the party who sends the final set of terms before the contract is performed is the one whose terms will prevail. Acceptance can also occur through conduct. For example, if goods are delivered and accepted without objection, the receiving party may be treated as having accepted the final set of contractual terms. The battle of the forms highlights the practical difficulties businesses face when competing contractual terms, including exclusion clauses, conflict with one another during commercial negotiations. Now that we have explored how exclusion clauses are incorporated into a contract, the next stage is interpretation and judicial control. Even when a clause has been successfully included, the courts must still decide whether it actually applies to the breach that occurred. The general principle is that liability can only be excluded through clear and precise wording. If the language is uncertain or ambiguous, the courts will step in to protect the weaker party. The first judicial control is the doctrine of Contra Proferentem. Under this rule, any ambiguity in an exclusion clause is interpreted against the party who drafted or seeks to rely on it. In practice, this means that where a clause can have two meanings, the court will choose the interpretation that favors the claimant rather than the defendant. Cases such as Baldry v. Marshall, Houghton v. Trafalgar Insurance, and White v. John Warwick demonstrate how strictly courts approach unclear wording. The second control is the main purpose rule. Here, the court may strike down an exclusion clause if it defeats the fundamental purpose of the contract itself. In other words, a party cannot rely on an exemption clause in a way that completely undermines the agreement's central objective. This principle was illustrated in cases such as Glynn v. Margetson and Evans Limited v. Andream Rosario Limited. Together, these judicial controls show that the courts do not simply accept exclusion clauses at face value. Instead, they carefully interpret them to ensure fairness, clarity, and consistency with the overall purpose of the contract. Building on the judicial controls we have just discussed, the final doctrine under interpretation is the doctrine of fundamental breach. This doctrine deals with breaches that are so serious they destroy the very core purpose of the contract itself. Historically, before 1964, courts treated fundamental breach as a strict rule of law. Under this older approach, a party could not rely on an exclusion clause to escape liability for such a serious failure. The reasoning was simple. A party should not be able to remove its most basic contractual obligations through fine print. However, the law later shifted toward a more flexible approach that emphasized freedom of contract. Following the case of UGS Finance in 1964, courts no longer automatically invalidated exclusion clauses in cases of fundamental breach. Instead, the issue became one of interpretation or construction. The key question now was whether the clause was drafted clearly enough to show that the parties genuinely intended to exclude liability, even for a fundamental failure. This modern position was firmly confirmed by the House of Lords in Suisse Atlantique in 1967, and later in Photo Production Limited v. Securicor in 1980. These decisions established that provided the wording is clear and unmistakable, even liability for a fundamental breach may be excluded. So, the modern approach reflects a balance between judicial fairness and contractual freedom. Courts will respect exclusion clauses, but only where the parties have expressed their intentions with absolute clarity. Now, let's clear up a vital distinction. Unlike the common law rules we just discussed, where everything relies on analyzing the unique factual scenarios, signatures, and timelines of a dispute, moving into statutory controls requires a completely different essay approach. In an AS or A-level exam, when you are hit with a straight, theory-based essay question rather than a problem scenario, you need to display a high-level conceptual understanding of the legal architecture. This brings us directly to the framework and scope of our first major piece of legislation, the Unfair Contract Terms Act 1977, or UCTA. Your first major point in an essay regarding statute must establish the core distinction. You need to explicitly show the examiner that you understand how Parliament divided the legal landscape. While UCTA historically covered a broader spectrum, it does not apply to consumer contracts anymore. Consumer disputes are strictly governed by the Consumer Rights Act 2015. Therefore, you must clearly state that UCTA's scope is restricted exclusively to business-to-business B2B contracts. Next, you need to critique the mechanism of the Act. Explain to the examiner that UCTA doesn't just evaluate fairness arbitrarily, it operates using two distinct statutory mechanisms. Depending on the type of breach being excluded, UCTA will either place an absolute ban on the clause, rendering it completely void as a matter of law, or it will subject the clause to the reasonableness test, where the court actively evaluates the fairness of the term at the time the contract was made. Finally, to maximize your evaluation marks, you must highlight the strict statutory exemptions. A great essay demonstrates comprehensive knowledge by pointing out that UCTA is not a universal fix. It does not apply to contracts concerning land transfers, insurance, company formation, maritime shipping, or international supply contracts. By outlining these boundaries, you show the examiner that you grasp the exact limits of parliamentary intervention. Now that we've established where UCTA applies, let's look at the specific sections you must quote to pick up your core knowledge marks. Now that we've outlined the overarching framework and scope of UCTA 1977, establishing that it strictly governs business-to-business transactions and uses distinct regulatory paths, we need to dive directly into the concrete text of the statute. In an AS or A-level essay, maximizing your knowledge marks requires you to cite the exact statutory provisions. This brings us to the first of our must-know sections, Section 2, which tackles negligence liability. To connect this back to our previous discussion on mechanisms, Section 2 is the perfect illustration of how the Act splits its approach. This entire section regulates clauses that attempt to exclude or restrict liability for a breach of a duty of care. First, let's look at the absolute statutory ban we just introduced. Under Section 2, subsection 1, the law draws a non-negotiable ethical line. A business can never exclude or restrict its liability for death or personal injury resulting from negligence. If a commercial contract contains a clause attempting to do this, it is automatically void from the outset. There is no judicial discretion here, and the courts cannot evaluate the context. The clause is simply struck down. However, look at how the mechanism completely shifts when we move to Section 2, subsection 2. If the business's negligence causes any other type of loss or damage, such as property damage or pure financial loss, the clause is not automatically banned. Instead, its validity depends entirely on the reasonableness test. The clause will only be legally enforceable if the business can actively prove to the court that the term was fair and reasonable to include. This clear split within Section 2 perfectly demonstrates how UCTA balances rigid public policy protection with commercial flexibility. Next, we need to examine how the Act handles standard contract breaches where negligence isn't involved at all. In our previous slide, we looked at Section 2, exploring how UCTA deals with tortious liability and negligence. But what happens when the dispute has nothing to do with carelessness or injury, and is instead a straight case of breaking a commercial agreement? To answer that in an essay, we have to move to the next vital core provisions on our checklist, Section 3 and Section 13. Let's begin with Section 3, which regulates liability for breach of contract. It is crucial to note for your essay that this section does not cover every single business agreement. It applies specifically when companies contract on one party's standard written terms of business. The rule here is designed to protect companies from being held hostage by another business's standard pre-drafted contract. Under Section 3, a party cannot exclude or restrict their liability for a total breach of contract, nor can they claim the right to perform a substantially different service, or no service at all, unless the clause is reasonable. Just like the property damage rules in Section 2, subsection 2, the burden falls on the contract's author to justify the restriction. But Parliament knew that clever businesses would try to bypass these rules entirely without using obvious exclusion clauses. This brings us directly to Section 13, which tackles disguised exclusions. To connect this conceptually, think of Section 13 as a statutory safety net. The rule here stops businesses from avoiding UTCA by hiding an exclusion clause behind tricky procedural or administrative hurdles. Instead of saying we are not liable, a disguised clause might focus on targets, like imposing onerous conditions, such as giving a buyer an impossibly severe time limit to report defects. Another common target is a clause stating that merely signing for a delivery acts as absolute proof that the goods are perfect. Section 13 catches these tricks and firmly dictates that these disguised terms must also pass the reasonableness test to be legally enforceable. Now that we have covered the key sections that trigger this requirement, our next logical question is, how exactly do judges determine if a clause is fair? On our next slide, we will break down the precise mechanics of the Section 11 reasonableness test. In our previous discussion, we explored the triggering provisions of UCTA, specifically Section 2, subsection 2, for property negligence, Section 3, for breach of standard terms, and Section 13 for disguised tricks. We noted that if a clause escapes an absolute ban under Section 2, subsection 1, Its ultimate legal survival depends entirely on a single mechanism. That mechanism is on our screen right now, the test of reasonableness, contained within Section 11 and Schedule 2. To present a highly critical argument in your essay, you must master the exact statutory timing of this test. Let's look at the core standard laid out in Section 11, subsection 1. The statute dictates that the term must have been a fair and reasonable one to include, having regard to the circumstances which were, or ought reasonably to have been, known to, or in the contemplation of the parties at the exact time the contract was made. This brings us to a critical, important note that you should always highlight to examiners. Fairness is judged purely at the time of making the contract. The courts are legally forbidden from using hindsight. It does not matter how catastrophic or unfair the breach seems when it actually happens down the line. The judge must mentally travel back to the day the contract was signed and evaluate what parties knew then. Finally, let's address the structural legal mechanics of the courtroom. Under Section 11, subsection 5, the statute explicitly establishes the burden of proof. The consumer or the injured party does not have to prove a clause is unreasonable. Instead, the burden lies entirely on the party claiming the clause is reasonable to actively prove that it is. But how does a business actually prove this to a skeptical judge? What specific elements do the courts look at? To find out, we need to turn to the statutory guidelines in Schedule 2, which we will analyze on our next slide. On our previous slide, we established the core standard of Section 11, subsection 1, learning that the test of reasonableness is strictly judged based on what the parties knew at the exact time the contract was made. We also saw that under Section 11, subsection 5, the burden of proof is placed squarely on the business attempting to rely on the clause. But how does a judge actually evaluate what was reasonable in a commercial context without being purely subjective? To maintain consistency, Parliament provided a concrete statutory checklist. This brings us directly to the 5 evaluation guidelines found in Schedule 2 of the Act, which judges use to systematically weigh up whether a business-to-business exclusion clause should stand. The first and often most heavily debated factor in an essay is bargaining power. The court evaluates the relative strength of the parties' negotiating positions. If a monopoly supplier forces a take-it-or-leave-it clause onto a small business with no alternative supply choices, the clause is highly likely to be deemed unreasonable. Second, the court looks at inducements. This examines whether the customer was given a deliberate choice, for instance, a significant price discount or benefit in exchange for voluntarily accepting the exclusion clause. If an inducement was present, the clause is much easier to justify as reasonable. A judge will ask whether the customer actually knew or reasonably should have known that the specific term existed. This directly links back to the common law notice rules we discussed earlier. If a term is buried, it fails the statutory fairness expectation. Our 4th guideline is conditions. This addresses the practicality of complying with any contractual conditions required to trigger liability. If a clause says we are only liable if you notify us of defects within 24 hours, the court assesses whether compliance with that condition was practically realistic at the time of contracting. Finally, the court considers special orders. This looks at whether the goods were custom-made or uniquely adapted specifically for the customer. If a business creates a highly bespoke, one-of-a-kind piece of machinery to your unique specifications, it is considered far more reasonable for them to limit their liability if something goes wrong. By analyzing these 5 statutory pillars, you can provide a highly sophisticated evaluation of business-to-business limits. Now that we have fully dismantled the statutory framework for commercial contracts under UCTA, we must turn to our final major statutory module, the rules governing business-to-consumer relationships under the Consumer Rights Act, 2015. On our previous slide, we concluded our analysis of the Unfair Contract Terms Act 1977, examining how its Schedule 2 guidelines evaluate reasonableness strictly within commercial, business-to-business environments. But remember the fundamental threshold distinction we made when we first introduced statutory controls. We noted that Parliament purposefully split the legal landscape in 2. Now we are crossing that legislative border to look at how the law protects private individuals. This brings us directly to the Consumer Rights Act 2015, or the CRA. To tie us back to our overarching timeline, you must emphasize in your essay that the CRA 2015 completely separated consumer contracts from business-to-business transactions. In doing so, it entirely replaced UCTA 1977 for consumer disputes. A classic mistake in exams is trying to apply UCTA reasonableness to a regular shopper. Make it clear to the examiner that the CRA holds exclusive jurisdiction here. Looking closely at its applicability, the scope of the CRA is precisely defined. It applies strictly to business-to-consumer B2C contracts, and it modernizes the law by covering three specific areas: goods, services, and, for the first time in statutory history, digital content, such as mobile apps or streaming services. To ensure your essay demonstrates exact technical precision, you need to reference the statutory key definitions found in Section 2 of the Act. The CRA explicitly dictates who qualifies for this high level of legal protection. First, a trader is defined as a person acting for purposes relating to their trade, business, craft, or profession. Second, a consumer is defined as an individual acting wholly or mainly outside their trade, business, craft, or profession. Finally, let's look at how the machinery of the courtroom handles a dispute over identity. Just as we saw UCTA shift the burden of proof regarding reasonableness, the CRA features its own distinct mechanism for the burden of proof. If a trader tries to claim in court that a contract is not a consumer contract in order to escape these strict rules, the statute dictates that it is up to the trader to prove it. The law automatically presumes the buyer is a consumer until the business proves otherwise. Now that we have established the structural framework, definitions, and scope of the CRA, how does this statute actually crush unfair terms? On our next slide, we will examine the absolute mandatory statutory bans that traders are completely forbidden from writing into their contracts. On our previous slide, we laid down the foundational framework of the Consumer Rights Act 2015, establishing its strict business-to-consumer scope and definition boundaries under Section 2. Now that we know exactly who a trader and a consumer are, we need to look at how the CRA actively transforms the content of a consumer contract. This brings us to statutory rights in goods, also known as the implied terms. When presenting your legal theory in an essay, you must explain that under the CRA 2015, certain core consumer protections are automatically implied into every single contract for goods as a matter of law. They exist instantly, whether the trader writes them in or not. There are three heavy-hitting statutory sections you must memorize for your revision. First, Section 9, Satisfactory Quality. This dictates that goods must meet the standard that a reasonable person would regard as satisfactory, factoring in the item's description, price point, and long-term durability. Second, Section 10, Fitness for a particular purpose. If a consumer explicitly or implicitly makes a specific purpose known to the trader, the goods must be fit for that exact purpose. Third, Section 11, As Described. This mandates that the final goods must strictly match any description, sample, or promotional model shown to the consumer before purchase. But how do these implied terms connect back to our main lecture topic on exclusion clauses? Look at the bottom of slide image B20149.jpg to see the absolute legal hammer of the CRA. The exclusion ban under Section 31. In your essay, contrast this directly with UCTA's flexibility. While UCTA allows business-to-business exclusion clauses to survive if they pass a reasonableness test, the CRA takes a far more aggressive protective stance for regular shoppers. Under Section 31, a trader cannot use an exclusion or limitation clause to restrict or escape their liability for breaches of Sections 9, 10, or 11. Any clause attempting to restrict these statutory rights is completely automatically void and unenforceable. There are no exceptions, no arguments about bargaining power, and no balancing tests. If a trader tries to say, no refunds for faulty items, Section 31 strikes it out of existence immediately. Now that we have covered how the CRA protects consumers when purchasing physical goods, we need to shift our focus to how the statute regulates contracts for services and digital content. On our previous slide, we examined how the Consumer Rights Act 2015 establishes strict, unexcludable protections for consumers purchasing tangible goods under Sections 9, 10, and 11, backed by the ironclad ban of Section 31. But what happens when a consumer isn't buying a physical product, but is instead paying for a task to be performed? To maintain structural cohesion in your essay, you must show how the CRA smoothly transitions its protective philosophy into the realm of intangible agreements. This brings us directly to statutory rights in services, as outlined here on slide image B1EEFE.jpg. When a consumer hires a trader to perform a service, whether that is getting car repairs done, contracting building work for a home, or seeking professional legal advice, the law step in exactly as it did with goods. It automatically inserts statutory quality standards directly into the heart of the agreement. For your revision, there are two core service sections you must be ready to cite. First, Section 49, Reasonable Care and Skill. This mandates that the service must be carried out with the exact standard of care expected of a reasonably competent professional. A trader cannot claim they did their best if their work falls below objective industry standards. Second, Section 52, Performance within a reasonable time. If the parties did not fix a specific deadline or time frame during negotiations, this statutory safety net ensures the service must be executed within a reasonable time window based on the circumstances. But let's tie this right back to the central theme of your exam essay, the validity of exclusion clauses. How does the CRA handle a business that tries to limit its liability for a botched service? Look at the final bullet point on slide image B1EFEF.jpg, the exclusion ban under Section 57. Just as Section 31 completely outlawed the exclusion of statutory rights in goods, Section 57 mirrors that absolute approach for services. The rule dictates that a trader cannot contract out of or limit their liability for a breach of Section 49. This is a vital evaluative point for your essay. By creating an absolute statutory bar under Section 57, Parliament has made a baseline of professional competence completely non-negotiable in consumer contracts. A business can print whatever terms they want on the back of a receipt or invoice, but the moment they try to exclude liability for a lack of reasonable care and skill, Section 57 renders that clause instantly void. Now that we have fully covered how the CRA protects consumers across both physical goods and intangible services, let's look at how these provisions are structured when applied to the modern digital economy. Previously, we examined how the Consumer Rights Act 2015 establishes strict, unexcludable protections for consumers in the traditional sectors of tangible goods and intangible services. But a truly excellent A-level essay must highlight the most forward-thinking element of this legislation: how Parliament modernized the law to adapt to the 21st century marketplace. This brings us directly to the rules governing statutory rights in digital content. Before the CRA 2015, digital assets like mobile apps, streaming services, software packages, or video games fell into a massive legal gray area under old statutes like UCTA. The CRA completely solved this by giving digital content its own explicit automatic statutory protections. For your revision, you must learn the specific trio of sections. First, Section 34. This establishes that digital content must meet the standard that a reasonable person would expect, taking into clear account its price, its description, and its overall durability or performance. Second, Section 35. Fitness for a particular purpose. If a consumer specifies a particular purpose to the trader before purchasing, such as verifying whether a piece of software is compatible with a specific operating system, the digital content must be fit for that purpose. Third, Section 36, as described. This mandates that the digital content must strictly match any description, trial version, or sample provided by the trader. But let's look at the absolute bottom line for your essay, which brings us right back to our central theme of exclusion clauses. How does the law deal with tech companies or platforms that hide use-at-your-own-risk disclaimers deep inside their digital terms and conditions? This is where we introduce the exclusion ban under Section 47. To maximize your assessment marks, emphasize this unified legislative approach to the examiner. Just like physical goods are protected by Section 31 and services are protected by Section 57, digital content is heavily guarded by Section 47. The rule is absolute. Any clause that attempts to exclude or restrict liability for a breach of Sections 34, 35, or 36 is completely void and automatically unenforceable. It does not matter if a user checked a box saying, "I agree to the terms" before downloading an app. If that app fails to meet satisfactory quality, the trader cannot contract out of their baseline liability. Now, if a trader's exclusion clause avoids these automatic bans under sections 31, 57, or 47, it faces one final comprehensive hurdle. On our next slide, we will examine the mechanism used for all remaining consumer terms, the statutory fairness test. On our previous slide, we looked at the specific, non-negotiable blacklisted terms under the Consumer Rights Act, learning that if a trader attempts to exclude core statutory obligations for goods, services, or digital content, the clause is completely dead on arrival. But what happens if a trader writes an exclusion or limitation clause that doesn't trigger those automatic bans, yet still feels heavily skewed against the ordinary shopper? This brings us directly to the ultimate comprehensive safety net of the CRA, the General Fairness Test, contained in Section 62. To build a flawless analytical framework in an essay, you must explain that Section 62 acts as a catch-all mechanism. Any exclusion or limitation clause that is not outright banned by Sections 31, 47, or 57 must still survive this strict statutory test of fairness to be legally enforceable. The rule laid out under Section 62 is clear. An unfair term in a consumer contract is simply not binding on the consumer. But how does the law objectively define unfair? As outlined on slide image B190ed.png, the statute sets out a two-pronged test. A contractual term is legally deemed unfair if it meets these specific criteria. First, it causes a significant imbalance in the parties' rights and obligations under the contract, specifically operating to the detriment of the consumer. Second, it positions the trader with an unfair advantage which runs completely contrary to the equitable requirement of good faith. In an essay response, always contrast this with UCTA's Section 11 reasonableness test. While UCTA balances commercial equity between businesses using the Schedule II guidelines, the CRA's Section 62 test actively tilts the scales to protect the weaker consumer from predatory, one-sided drafting. If the trader slips a sneaky, imbalanced limitation into the fine print, the court will deploy Section 62 to strip its legal power instantly. But judges don't have to guess what kinds of terms typically cross this line. To make the Section 62 test practical, the statute provides an explicit schedule of terms that are automatically suspected of being unfair. On our next slide, we will explore the statutory index, famously known as the gray list. On our previous slide, we unpacked the abstract core principles of the Section 62 General Fairness Test, noting how a term fails if it creates a significant imbalance or violates good faith. However, to help judges apply this test smoothly, Parliament attached a practical blueprint. This brings us directly to the gray list, found in Schedule 2 of the Consumer Rights Act. When writing your essay, it is vital to explain this specific terminology to the examiner. In contrast to the blacklisted terms we saw earlier under Sections 31, 47, and 57, which are completely banned, the terms on the gray list are not automatically void. Instead, Schedule 2 contains an illustrative list of terms that are strongly suspected of being unfair. It effectively shifts the psychological burden onto the trader to prove why such a clause is necessary. Let's look at three classic high-yielding examples. First, unilateral changes. This catches clauses allowing the trader to alter the core characteristics of the goods or services without a valid reason after the contract is already running. For instance, a gym changing its facilities or a software company removing major features without giving you a say. Second, disproportionate termination fees. This targets clauses charging high, exorbitant penalty sums if the consumer decides to cancel the agreement early. The law expects termination fees to reflect actual administrative costs, not act as a financial punishment. Third, price escalation. This monitors terms allowing the trader to increase the price after the contract is finalized, without letting the consumer back out of the deal completely free of charge. If an exam problem scenario contains any of these mechanisms, you should immediately flag them as Schedule 2 gray list terms, meaning they are highly vulnerable to being struck down under Section 62. However, the fairness test does not have an infinite reach. The statute explicitly seals off certain terms from being assessed for fairness at all, provided they meet strict transparency rules. On our next slide, we will examine these crucial safe harbors, known as the core exemptions. On our previous slide, we examined the Schedule 2 gray list, which details the terms heavily suspected of being unfair under the Section 62 general test. However, it is vital to understand that judicial intervention has strict boundaries. The law fundamentally respects freedom of contract when it comes to the heart of the bargain itself. This introduces the core terms exemption contained in Section 64 of the Consumer Rights Act. As a crucial rule for your essay, Section 64 dictates that the courts will not assess whether a contract term is fair under Section 62 if that term relates strictly to two specific pillars. First, the main subject matter of the contract, which simply means the core deal or the essential product you are purchasing. Second, the appropriateness of the price relative to the goods or services supplied. In short, judges are not there to rescue consumers from a bad financial bargain or tell a business what they are allowed to charge. But there is a massive statutory caveat to be aware of here. As noted under the catch, a trader cannot simply hide an unfair or unusual pricing mechanism in the fine print and claim immunity under Section 64. To completely enjoy immunity from the Section 62 fairness test, these core terms must successfully pass the statutory dual requirement. They must be transparent, meaning they are written in plain, intelligible language that an ordinary person can grasp. And they must be prominent, meaning the term was brought to the attention of an average consumer in such an explicit way that they were clearly aware of it before entering the contract. If a pricing term is buried deep inside a lengthy document, it loses its Section 64 immunity, allowing judges to tear it apart using the fairness test. Now, while Section 64 provides a conditional safe harbor for core terms like price and subject matter, there are certain types of clauses that can never seek refuge anywhere in the Consumer Rights Act. On our next slide, we will shift away from fairness balances to look at an absolute, unarguable boundary, the statutory absolute bar to negligence. On our previous slide, we discussed the core terms exemption under Section 64, seeing how price and subject matter can enjoy a conditional safe harbor from the fairness test, provided they meet the dual criteria of transparency and prominence. However, there is one area of the law where no amount of transparency, prominence, or mutual agreement will ever save a trader's exclusion clause. This brings us to the ultimate boundary of consumer protection, the absolute bar on negligence contained in Section 65. When evaluating this in an essay, you should make it clear that public safety and basic tortious accountability are strictly protected under the Act. Parliament treats bodily harm as completely non-negotiable. This is codified explicitly under Section 65, subsection 1. The rule states that a trader cannot exclude or restrict liability for death or personal injury resulting from negligence. This is a total, absolute prohibition. If a consumer signs a waiver before going on a theme park ride or clicks agree on an app and they are injured due to the trader's negligence, that exclusion clause is instantly void. There is no balancing test, no argument for reasonableness, and no exemption. But what happens if the trader's negligence causes harm to a consumer's possessions rather than their person? The law treats other loss or damage differently. If negligence causes property damage, for instance, if a faulty household appliance catches fire and burns a consumer's carpet, a clause limiting liability for that property damage is not subjected to an automatic ban. Instead, the clause is permitted to step into the courtroom, but it must successfully pass the rigorous Section 62 fairness test that we broke down earlier. The trader will have to prove that limiting liability for property damage did not create a significant imbalance contrary to good faith. This distinction mirrors the classic approach we saw under UCTA for business contracts, but enforces it with the consumer-first severity of the CRA. Now that we have dismantled the absolute bars, the general fairness test, the gray list, and the core exemptions, we have completely mapped out the statutory controls under the Consumer Rights Act. Now, how do all of these mechanisms fit into the bigger picture? On our next slide, we will step back and transition into an evaluation in general, critically analyzing how both common law controls and statutory rules under UCTA and the CRA work together to police exclusion clauses across the entire landscape of contract law. Now that we have dismantled the individual statutory controls under both the Unfair Contract Terms Act and the Consumer Rights Act, we need to transition into critical analysis. In a top-tier A-level essay, you cannot just list these statutes. You must evaluate how effectively the law balances two competing tensions: the need to protect the vulnerable and the need to preserve commercial flexibility. The modern framework achieves this balance through 4 distinct structural achievements. First, consider vulnerable protection under the CRA 2015. The Act provides a complete, robust shield for individual consumers. By enforcing a strict fairness standard across standard terms, it completely strips away the risk of exploitation hidden deep within business small print. It recognizes that consumers lack bargaining power and cannot negotiate terms, so the law actively tilts the scales in their favor. Second, contrast this with B2B flexibility under UCTA 1977. Instead of applying the same rigid consumer bans to the business world, UCTA preserves commercial freedom. It achieves this by using a contextual reasonableness test, which allows judges to look at real-world fairness variables, such as the relative bargaining power of the firms, or who was in a better position to buy insurance for the risk. Third, the law establishes what can be called the ethical floor. Across both consumer and commercial transactions, public safety remains absolutely non-negotiable. There is a total, uncompromisable statutory ban on contracting out of liability for death or personal injury caused by negligence. No matter how much money or bargaining power is involved, human life cannot be bargained away. Fourth, the framework fiercely protects commercial certainty. It grants maximum autonomy to equal giants. When multinational corporations sit down to draft massive deals, the law consciously steps back to let them freely allocate risk however they see fit. This hands-off approach provides companies with the predictable pricing and liability baseline they strictly need to operate efficiently. This framework perfectly captures the strengths of the current system. But a truly sophisticated evaluation doesn't stop at the benefits. To secure the highest marks, we must also examine the systemic flaws, complex legal gray areas, and practical hurdles that persist in this area of contract law. On our next slide, we will shift focus to look at the other side of the coin, the ongoing arguments regarding complexity and loopholes. While our previous section highlighted the brilliant structural balance between protecting consumers and giving big businesses flexibility, a top-tier A-level essay demands critical depth. We must look at the darker side of the coin. Despite the statutory overhauls, the English system for controlling exclusion clauses remains plagued by immense complexity, high costs, and archaic legal tech. There are 4 critical systematic flaws you should utilize to critically evaluate this topic. First, consider the signature trap. Following the strict common law precedent in Lestrange v. Graucob, signing a document binds a party to absolutely everything within it, no matter how unread or packed with dense legalese it is. While the CRA 2015 largely saves consumers from this trap, it remains a major, catastrophic danger for sole traders and small businesses. Because they are legally classified as businesses, they lack consumer rights and get routinely crushed by predatory standard terms they had no choice but to sign. Second, look at the 3-step hurdle. Determining whether an exclusion clause actually works is an exhausting, multi-layered process. A claimant must navigate incorporation, then construction, and finally the relevant statute. This complex judicial obstacle course forces astronomical, expensive legal bills onto small firms, often pricing them completely out of justice before they even step into a courtroom. Third, we have the flaw of subjective reasonableness. While UCTA's judicial flexibility is highly praised for its commercial adaptability, that exact flexibility breeds widespread unpredictability. Because the Section 11 test is highly discretionary, different judges can look at identical commercial facts and reach completely opposite verdicts, severely undermining commercial certainty. Fourth, consider the issue of outdated digital notice. Our century-old common law rules, built on old physical tickets and railway signs, fundamentally struggle to define what counts as reasonable notice for terms buried behind modern hyperlinks, scroll boxes, and complex mobile apps. The law is constantly lagging behind the rapid evolution of the digital economy. By presenting these critical arguments, you demonstrate a complete, balanced understanding of how these controls function in reality. Now that we have weighed up both the elegant protections and the deep technical flaws of the modern framework, let's bring our entire masterclass to a definitive close. On our final slide, we will pull all these threads together into a high-scoring, sophisticated conclusion. To bring our entire exploration of exclusion clauses together, we can summarize the English legal approach using a single, high-scoring evaluative phrase. The The UK system operates as a classic dual-speed model. On one hand, it is fiercely protective for consumers, utilizing the Consumer Rights Act 2015 to completely strip away unfair terms and establish an absolute shield against corporate overreach. On the other hand, it is highly pragmatic for big businesses, using the Unfair Contract Terms Act 1977 to preserve commercial freedom and certainty among equal economic giants. However, as a critical final point for any essay, this dual-speed approach is inherently perilous for small to medium enterprises. Because SMEs are legally classified as businesses, they fall directly into the structural gap between the two frameworks, frequently finding themselves trapped by dense, unfair standard terms without any of the robust statutory safety nets enjoyed by ordinary consumers. Understanding this tension between consumer protection, commercial pragmatism, and small business vulnerability is the ultimate key to mastering this topic and securing top marks on your exam. That brings us to the end of our deep dive into exclusion and limitation clauses. Thank you all so much for your time. I will see you in the next lecture.